usually awarded to the successful party by the court. The unsuccessful party is usually made to pay the cost to the successful party. The definitions of cost can be referred to Order 59 Rule 1 Sub 1, which includes fees, charges, disbursements, and remunerations which are payable under court order. Costs can be divided into solicitor and client costs and party costs. The latter must be given by the court to compensate the other litigants for expenses that he had incurred in the litigation. According to Order 59 Rules 2 Sub 2, the power of court to award costs is discretionary and the court shall have full power to determine by whom and to what extent the costs are to be paid. It is clearly demonstrated in the case of Menteri Hal Ehwal Dalam Negeri versus Kapal Singh. According to Order 59 Rule 3 Sub 1, an order for cost is therefore essential. For example, the court must make an order as to cost to enable a party to recover such costs incidental to the proceeding.
Next, we will also be discussing the factors that are considered when awarding costs. In awarding costs, Order 59 Rule 16 of ROC requires the court to consider several factors. First, the complexity and novelty of the cost. Second, the specialized knowledge, responsibility required of and time expended by the counsel. Third, the number and importance of the documents prepared or produced. Fourth, the place and circumstances of the business involved. Fifth, the importance of the cost or matter to the client. And lastly, the amount or value of money or property involved. Additionally, the court may also consider other matters such as settlement offer, improper actions by a party, the party's conduct before and during the proceedings, the attempts to resolve the suit through dispute resolution method, and lastly, the cost incurred due to unnecessary claims or issues raised. Now, let's move on to when the court will order the payment of costs. It occurs in several circumstances. First, when party success at the end of the action. Second, when a party is successful in an interlocutory application. Third, when one party applies for judgment in default of appearance or of defence. And lastly, can be made when party applies for postponement of a matter on the day of hearing. Furthermore, when judgment in default of appearance is set aside, there are potential cost orders that may be given, and one such order is referred to as cost thrown away. According to Order 59 Rule 1 Paragraph 3, where proceedings have been ineffective or have been subsequently set aside, the party in whose favour this order is made shall be entitled to his cost of the proceedings or that part in respect of which is made. Here, the term cost thrown away refers to the situation where costs have been wasted by a party.
The order of cost thrown away usually will be granted when the judgment in default of appearance or defence has been set aside. If the judgment in default is regular, the defendant has to pay for the cost thrown away. If it is irregular, the plaintiff would have to pay for the cost thrown away. As far as the questions is concerned, in the case where a regular judgment in default of appearance is successfully set aside on the ground that the defendant has a prima facie defence, the order that is likely to be made by the court is the order of cost thrown away. For example, in the case of Darshan, it was held that the court has to ascertain whether the judgment in default was regular. If it was not, the respondent would be entitled to have it set aside as of right with cause in her favour. However, if the judgment in default was regular, the respondent can still succeed to have it set aside if she can show that she has a defence on merits, but in such circumstances, she will be penalised with costs. This matter was also discussed in the case of Hayman, where Lord Daning said that if by some oversight or mistake a party does not appear at the court on the hearing and the judgment goes against him, but justice still can be done by compensating the other side for any costs and troubles to which he has been put, then a new trial ought to be granted. The party asking for a new trial ought to have shown some defence on merits.
The same principle was also applied in the case of Bunga Singh against Koay, where it was ruled that if the court is satisfied that a party was prevented from appearing by sufficient cause on the day of the hearing, and if justice can be done by compensating the other side for any cost thrown away, the court is bound to set aside the judgment and order a new trial. Next, we will be discussing the case of Chong Quang Ying and other against Levis Lavagna, in which during the application of judgment in default, plaintiff applied for the issue of concurrent writ to be served out of the jurisdiction to the defendant who was living in England by AR registered post. The court held that such service deemed to be good and sufficient service, therefore a regular judgment in default. However, there were merit which shown that the defendant had a prima facie defence. The applicant should bear them by paying to the plaintiff all costs thrown away by reason of the default. Moving on, in the case of Galaxy Corporation Sdn Bhd against Ng Ai Gyo and another, plaintiff claimed against defendant for the outstanding amount due to the plaintiff for goods supplied to the defendant. Defendant applied to set aside the judgment in default of appearance on the ground that it was not a regular judgment, as the writ was not served to him. The court held that there is a strong probability that the writ was actually served on the defendant. Therefore, it is a regular judgment. Defendant in the affidavit has shown a defense on the merit. In the circumstances, judgment in default of appearance is set aside. With that, defendant will bear all costs thrown away by the plaintiff by reason of his default.
Next, the order of costs thrown away given by the court can also be seen in the federal court case of Jin Kiam Seong and others versus Ran Hye Sing. So in this case, JIDA has been obtained on the claim regarding the money laundering transactions against the appellant. So appellant has applied to set aside the default judgment, and in its affidavit, it has shown that there is prima facie defense. So the court held that the appellant should be allowed to defend on the conditions of the payment of all the costs thrown away as a result of their failure to enter the appearance. Following, the next possible cost order that will be given by the court when the judgment in default is successfully being set aside is the cost in the cost. So it's defined under Order 59, Rule 1, Sub-Rule 3 of the ROC. So basically, this order means that the cost of the interlocutory proceedings will be awarded according to the final outcome of the trials. So it means that whoever wins the final case will get the interlocutory cost. The court may give the order in the way of plaintiff cost in the cost or defendant cost in the cost. So for plaintiff cost in the cost, it means that if plaintiff wins the case, he will get the interlocutory cost. But if plaintiff loses the case, it does not have to pay the defendant cost. The same goes to defendant cost in the cost. So if defendant wins the case, defendant can get the interlocutory cost. But if defendant loses the case, defendant no need to pay plaintiff cost.
Next, order for costs in the cost can be seen in the case of Yayasan Malacca and Fortran Corporation. In this case, the High Court of KL allowed the judgment in default against the defendant to be set aside with costs in the cost. This is due to the fact that the court found that there is a defense on the merits which have been raised in 3 affidavits filed in support of the application to set aside. Hence, the plaintiff cannot be said to have been prejudiced in having no clue whatsoever as to the defense raised. In another case of Ahmad Ansar bin Taib and Muhammad Arif bin Muhammad Yusuf Latif and another appeal, since the defendant have been deprived of access to justice and the right to be heard in an open court of their defense to the plaintiff claim in negligence against them, it can be said that it's appropriate for the court to intervene and correct the injustice and prejudice which has been caused to the defendants by setting aside the judgment obtained against them with costs in the cost. In conclusion, order as to cost can vary depending on the specific circumstances, but it also depends on the discretion of the court in making the decision after considering different factors of each case. The court will only allow a reasonable sum as cost to the winning party, and this sum may well be lower than the actual sum incurred for the whole matter. So that's all from us. Thank you. Bye bye.